Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Ayman Hafiz bin Azali, and today we are from Group 5. We will be presenting regarding whether the conceptual framework is helpful in solving the accounting for Islamic financial instruments. Alright, so this is the content of the presentation. The first one, we will explain briefly about the Islamic financial instruments. Next one, we will explain about the limitation of the conceptual framework. And lastly, we will discuss about the cases in Malaysia regarding the issue. Okay, so first of all, we need to know that in Islamic finance, there are 6 basic principles in the Sharia guideline that we must follow. Okay, so the first one is the interest is prohibited, which is riba. Next, the risk should be shared. Okay, so the aim of this principle is to safeguard the parties of a transactions. And the third one is speculative behavior is prohibited, which is mashir. This means that operation based on random event or speculation and not on the action of the parties aim on generating income are considered to be invalid in Sharia. Next, the use of asymmetric information or uncertain information is banned, which is qarar. Next, trade and investment in prohibited assets or activities are banned. This means that any trading, direct or indirect, in investments on certain goods or activities such as alcoholic drinks, pork, weapons, tobacco, pornography, gambling and placing bets are prohibited. And last one is the obligation to have real assets underlying all financial transactions. Okay, so this means that all financial transactions must have real activities underpinning them and not be a mere exchange of sum of money or the buying and selling of financial debts. Okay, so this is the types of Islamic financial instruments. There are 5 types, which are murabahah, istisna, mudarabah, musyarakah, and ijarah. Alright, so let's move on to the first type of financial instrument, which is murabahah. Okay, so what is murabahah? Murabahah is an Islamic financing structure in which the seller and buyer agree to the cost and the markup of an asset. It is not an interest-bearing loan called ribawi, but is an acceptable form of credit sale under the Sharia guideline. Okay, so the purchaser does not become the true owner until the loan is fully paid. Okay, this is an illustration of what murabahah is. Okay, so the bank will initially take the role of the buyer and purchase the goods from the supplier as per the customer's requirement, along with the customer's consent that they will purchase the same stock from the bank plus premium. Okay, so the customers can either pay to the bank on the installment basis or as one-off payment on pre-agreed future date. Okay, so there are 5 types of pillar of murabahah: seller, buyer, goods, price, and sirah, which is offer and acceptance, ijab and kabul. Okay, next one is condition of murabahah. Okay, so murabahah must be in physical or constructive position of the seller. It must be instant and absolute. Be property having value. Not be used in non-sharia compliant purposes. Be specific and identifiable. Buyback arrangement is not allowed. Delivery and price should be certain. Must be unconditional and only to purchase some tangible good or commodity. Okay, so what is the difference between murabahah and conventional loan? Okay, so murabahah is a sale contract while conventional loan is interest-based lending agreement. The subject matter to the contract of murabahah is the asset while conventional loan is the loan. Okay, so murabahah, the relationship between parties is of buyer and the buyer and the seller, while the conventional loan is between the borrower and the lender. And lastly, murabahah does not permit profit from late payment fees, while in conventional loan, a penalty is charged in case of late payment, which is riba. Let's move on to the second type of Islamic financial instrument, which is istisna. Okay, what is istisna? Istisna is a contract which seller sells to a purchaser an asset which is yet to be constructed, built, or manufactured according to agreed specifications. It is delivered on an agreed specified future date at an agreed predetermined price. Okay, so the component of istisna is contracting parties comprising seller and purchaser, offer and acceptance, which is ijab and kabul, istisna asset, price and payment mode, and lastly is istisna project and delivery of istisna asset. Okay, so what is contracting parties? Contracting parties must be a seller, which is sani, and customer, mustani. It must be a natural person or a legal entity who must have the legal capacity to enter istisna contract, and a party to an istisna contract may enter through an agent, which is wakil. The conditions of istisna is the contract must be stated in a clear terms and conditions. The price involved must be specified. The contract must be include the quantity of good, the quality of material used, the type, dimensions, period taken, and the place of delivery of the project. And lastly, the project can be manufactured by any specific manufacturer or manufactured from specific materials. Okay, so there are two types of istisna, which is classical istisna and parallel istisna. Okay, so for the classical istisna, it is a normal contract which involves two parties, which is the customers and the manufacturer. Okay, so this is the structure for classical istisna. Okay, the customer will pay as agreed in the development to the manufacturer, and then the manufacturer will deliver the specified good to the customer. Okay, for the parallel istisna, it consists of two series of separate contract, whereby the first contract between the bank and the manufacturer, and the second contract is between the customer and the bank. Okay, so this is the structure for the parallel istisna. Firstly, the customer will enter the contract with the bank, and then the bank will enter the istisna contract with the manufacturer. And then the manufacturer will deliver the asset to the bank, and the bank will deliver the asset to the customer. Okay, I think that's all from me. I will pass to the next presenter to present about the remaining three types of financial instruments.
Assalamualaikum, my name is Muhammad Syamil Asfar bin Syafian, and I will continue talking about the Islamic financial instrument. The third one is about mudharabah. What is mudharabah? Mudharabah is a partnership where one party called Rabul Mal invest in a business venture, while the other called mudarib or working partners manage the business. If the venture is successful and generate profit, this profit will be distributed among both partners on a predetermined ratio. So there are two types of mudharabah. First is restricted mudharabah, where the investor specify a particular business or project where the investment fund are to be used. The second one is unrestricted mudharabah, where the investor give mudarib permission without any restriction to fund into any type of business that suit the financial goals. Authority of the investor. In mudharabah, the investor leaves everything to mudarib with no interference from his side, but he has the authority to oversee the working partner's activities and work with him if he consent. There are 5 roles of mudarib: trustee, agent, liable, employee, and partner. In terms of liable, usually if the business venture suffer loss, the loss will be absorbed solely by the investor. But if the business loss occur due to negligence of mudarib, he will be fully responsible. In terms of employee, if mudarabah become void, mudarib is eligible to become an employee and entitled to get a normal salary. The next is about termination of mudarabah. The mudarabah will stand terminate when the period specified in the contract expired, or it will be terminated when the two parties giving notice. The following must be considered at the time of termination. The first is if all assets of the mudarabah are in cash form at the time of termination, and some profit has been earned on the principal amount, it shall be distributed between the parties according to the agreed ratio. If all assets of mudarabah are not in cash form, it will be sold and liquidated so that the actual profit may be determined. And the last one is the capital of the investor will be the capital of the investor will be returned to the investor, and the remaining amount will be considered as profit, and this profit will be distributed according to the agreed ratio. Okay, the next Islamic financial instrument is about musyarakah. In Arabic, musyarakah means sharing, participation, missing share of two or more parties. Musyarakah in terms of business partnership is where partnership under which two or more parties contribute towards the capital of a joint underlying commercial venture in the expectation of profit. If the partnership incur loss, the loss will be borne in proportion to the each partner capital contribution. So the difference between musyarakah and the conventional partnership is where musyarakah structure is subject to the additional syariah requirement and safeguard. This is the example of the requirement and safeguard for musyarakah. Okay, next is musyarakah in terms of equity-based financing. There are two types of equity-based financing, permanent musyarakah and diminishing musyarakah. Permanent musyarakah is where Islamic bank participate in the equity of a project and receive a share of profit on a pro rata basis. The period of the contract is not specified, so it will continue as long as the parties concerned wish it to continue. Diminishing musyarakah is where a method through the equity of the bank keep on reducing its equity in the project and ultimately transfer the ownership of the asset on the participant. Understanding diminishing musyarakah. So the situation is where Ali want to purchase a house, but he has a limited fund. And Islam only permitted trade and forbid interest. So Ali then approached Islamic bank, and the Islamic banker explained that the concept of home financing based on partnership. This is where the bank and Ali will jointly purchase the selected house, which Ali contribute a certain value as his share, and the bank will contribute the balance amounts. And thus, now the house is owned by Ali and the bank. However, since Ali want to enjoy the complete usage of the house, the bank agree to rent its share of the house to Ali for an agreed rent, since Ali want to eventually secure the full ownership of the house. Ali monthly installment component comprised of two components: the rent, since he is occupying the house, and then the amount paid to purchase the portion of the house from the bank. And each month, when Ali pay the installment, the bank ownership will reduce, and therefore the rent payable will reduce. With the purchase of the last portion, Ali become the ultimate owner of the house. Okay, next is about the difference between non-interest and interest-based home financing. So, obviously, in interest-based home financing, the bank will profit from the interest charged on the principal amount. And then for the early settlement for Islamic bank, the customer only has to pay the up-to-date rent using the house and purchase the remaining ownership as above. But for interest-based home financing, the customer could incur penalty due to the lock-in period if they want to for early settlement. Okay, the next Islamic financial instrument is ijarah. So what is ijarah? Ijarah can simply mean leasing or hiring. Ijarah is an agreement between two parties, one being the owner of the asset who give possession of the asset for the use of the other party on an agreed rental over mutually agreed period. So how ijarah works? So this is a mechanism of ijarah Islamic banking. So the first is where the customer approach the bank with the request of ijarah financing. Then the bank purchase the item required for the leasing and receive the title of ownership from the vendor. Next, the bank will give the asset to the customer. In return, customer make periodic payment as per contract. And at the end of the contract, the asset title transfer to the customer as per Sharia compliant. Okay, next is about the type of ijarah. There are two types of ijarah, operating lease and financial lease. The difference between operating lease and financial lease is where in operating lease, the ownership of the lease asset will remain with the bank at the end of the lease period, while financial lease, ijarah min tanhiya bitamlik, where the lessor will transfer the lease asset to the lessee at the end of lease period after the lessee has paid all the installment without delay. The transfer of ownership could take place in the one of following manner, where the bank promised to transfer the ownership on the basis of ordinary or conditional gift, or the bank promised to transfer the property through sale. Okay, next is about the difference between ijarah and conventional leasing system. In ijarah, if finance vehicle has lost its usage purpose, the customer is not liable to pay the rental for the period in which the vehicle is not functional because it is on rent. For example, If the vehicle reach an accident and is garaged for 1 month for repair, the customer is not required to pay the rental for the month unless the non-usability of the vehicle due to misconduct, negligence, and breach of the term of the contract by the customer. Islamic Bank does not profit charging customer any penalty for late payment as the rental amount is already agreed. However, this feature can be easily abused. Therefore, the customer obtaining vehicle finance is required to make a pre-agreed donation to charity through the bank in case such delay payment. The donation is prohibited from entering the investment profit pool of the bank. For early settlement, the bank will terminate ijarah contract and sell the vehicle under the sale contract on which the terms are to be agreed between both parties. For commissioner leasing system, the monthly payment need to be paid irrespective of the usage condition of the vehicle, and the late payment charge on delay payment shall constitute in bank account.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Ali, and now I will go to the limitation of conceptual framework. So, as far as we know, conceptual framework is used for us to understand the concepts and the terms that used in the accounting standards, and it is very important for us to understand and to know what needs to be done when we face with challenges. However, there is still some limitation when we are using conceptual framework. So now we will go to the limitations. The first limitation is it is extremely difficult for us to establish our own framework. The rich and developed countries can set up their own conceptual framework, but the countries that are still developing will find it very difficult and time consuming to do it. One of the reasons is because we still lack expertise and knowledge for us to truly develop our own conceptual framework that we explain the details in the accounting standards. So now the second limitation is about the rigidity that creeps into the standard accounting practices due to the implementation of framework. So when we set up our own framework, we will expect that the accounting standards will follow our own conceptual framework. This will cause the new ideas to be difficult to be implemented in the accounting standards, as the world is always changing and the issue that we face may be different from the issues that we have faced before. So the rigidity does not help, and we want to solve the issues by only using the conceptual framework. Next, the conflict that may arise between the framework and accounting standards that already in use before the conceptual framework was introduced. So in this situation, the conflict arises as conceptual framework may not agree with the accounting standards that has been used before. So when there is a conflict, the users will have some difficulties when want to determine the proper treatment for the issues. So next, the framework may be beneficial to only some interested group of individuals who are recognized as users, and while the other users may not be benefited from the framework itself. So when the framework was introduced, those users who has self-interest will try to develop the framework to their own advantages, and it will cause the other users will not be able to be benefited from the conceptual framework. So in this case, it will be unfair for the users as a whole, because the framework itself will always helpful to those who implement the framework itself. And next, we will go to the limitation, the differences between the accounting standards and how the conceptual framework cannot help in solving the differences. So now I will use the accounting standards that was introduced by accounting and auditing organization for Islamic financial institutions and Malaysian financial reporting standards that adopted IFRS. So we will go to one of the difference, which is investment accounts. So under Islamic financial institution standards, the accounting treatment for investment account will depending on the issue. So the first one is unrestricted investment account, and the second one is restricted investment account. So unrestricted investment account is an account which the Islamic bank will not have any restrictions when they want to use the account for investments. However, for restricted investment account is when the owner of the account will impose some restrictions to the bank as to where, how, and for what purpose his funds are to be invested. And for unrestricted investment account, it will classify as its own element under the balance sheets between liability and equity, while a restricted investment account will be considered as off balance sheet item. So it will not be it will not be treated in the balance sheets. It will not be shown in the balance sheets. So, however, depending on IFRS, the definitions and treatment used by Islamic financial institution will not be applied. First, IFRS only recognize three elements of the balance sheets and is being used by MFRS as well, which is asset, liability, and equity. So it does not have any intermediary category between the liability and equity. Second, IFRS does not attach significance regarding the status of the investment itself. So instead, investment account will be reported on the balance sheet if it gives rise to liability under IA Act under Standard 37 provisions, contingent liability and contingent assets, or as a financial liability under Standard number 32 financial instrument presentations. So in this issue, conceptual framework only treated Islamic financial instruments as a general because it has some similarities between the conventional instruments and Islamic instruments. However, as Islamic financial institution wants to avoid uncertainty issues and also avoid riba or interest charge, it is very difficult for the Islamic users, to treat it as a conventional. So from here we can see the limitations because it cannot address properly the differences and help to solve the issues faced by the users due to the differences between who are issuing the standards itself, as IFRS will focus on conventional financial instruments while AAOIFI will focus more on Islamic financial instruments to help Islamic users to do businesses without having to worry about is legal in Sharia or not. So that's all for the limitation of conceptual framework. Now I will pass to my other teammates for the next explanations.
So I'm going to explain or to talk about cases that happened in Malaysia, which is Arab Malaysian Bank versus Taman Ihsan Jaya Sendirian Berhad and Aus. Without any further ado, let's go. So in 2018, there was a conflict occurs between three parties. So the first party is Arab Malaysian Finance, which is the plaintiff, and second one Taman Ihsan Jaya Sendirian Berhad and Aus, which is the defendant, and lastly Koperasi Seri Kota Bukit Ceraka Berhad, which is the third party. So the story begins when the defendant Taman Ihsan Jaya bought a property from the third party, and then they paid only portion of the purchase price. Later on, they need some money to settle the balance of the purchase price. So they want to make a loan with the Arab Malaysian Finance, which is the plaintiff. The plaintiff then suggests that defendant to sell its property based on the amount of the balance of the purchase price under bank's property purchase agreement, which is PPA. So after the defendant sell the property, the money that they received from the Arab Malaysian Finance, they will use it to settle the balance payment to the third party. The issue is whether there is involvement of elements that are not approved by the religion of Islam. So as we know, the decision that have been made is from the civil court and not from the Sharia court. It states that the contract of buy bitaman ajil that been used in Islamic finance does not follow the Islamic Sharia because only the Imam Shafi'i accept it and not for the others. Therefore, the High Court has ruled that the contract of buy bitaman ajil is invalid for not following the elements that have been approved by Islam in Section 2 of Islamic Banking Act 1983. This case had become a dispute of many parties when matters involving Islamic law were decided by a High Court and not by the Sharia Court. It becomes a conflict because the Islamic financial system falls under jurisdiction of the civil court. The fact that the case related to Islamic financial instruments still has to be brought to the court shows that there is an area in conceptual framework that need to be updated. So the summary from this case, it appears that Islamic financial instruments are still cannot be implemented wholly as there are still uncertainty in business. Moreover, if one of the party did trade using conventional treatment, it will be hard to know the difference between Islamic financial instruments and the conventional. Last but not least, conventional financial instruments are still preferable compared to Islamic, as the conceptual framework also focus on conventional financial instrument. This shows that conceptual framework has limitation when dealing with specified issue such as buy bitaman ajil contract. So in conclusion, there are a lot of things that can be improved in the conceptual framework, especially for the Islamic financial instruments. This is to ensure less confusion when we are dealing with the Islamic financial instruments and to make sure that the financial instrument is legal from Sharia point of view and will be the main instruments worldwide. So that's all from us. Thank you for listening.